It is a tried and true tactic of the Donald Trump playbook. Turn anything into political score settling and grist for the mill of grievance politics. And today, lawyers for the ex-president filed a motion for a mistrial in a civil fraud case against him in New York that threatens to bring down the Trump organization and forever tarnish his brand as a business mogul. In that motion, Trump's team accuses Judge Arthur Engoron and his staff of political bias. The motion is filled to the brim with incredibly dramatic language alleging political bias. It says, quote, "Only the grant of a mistrial can salvage what is left of the rule of law." Trump's lawyers also took aim at the judge's law clerk, included photos of the clerk, as well as her campaign donation history in their public filing. That is even after the judge placed a limited gag order on Donald Trump that barred him from commenting on court staff. Trump's lawyers were then prohibited from discussing the judge's confidential communications with his staff. The length of the trial so far has been punctuated by skirmishes over Trump's rhetoric. His targeting of Judge Engoron's clerk led to fines, even a threat of imprisonment. The filing today is inviting questions about whether Team Trump has once again violated the gag order. You know, that Trump and his team are claiming exemplifies Judge Engoron's bias against him. And that is where we start today with former Assistant U.S. Attorney and MSNBC legal analyst Glenn Kirshner, MSNBC legal analyst Lisa Rubin, and former top State Department official during the Obama administration, Rick Stengel. Glenn, let's start with you. Talk us through this filing. Why did Trump's team go after the judge and his staff?
You know, for a couple of reasons, Alicia. I mean, one, they need to make motions that they believe have some merit, even if it's a foregone conclusion that Judge Engoron is not going to grant a motion concluding that he is hopelessly biased, which is really what he would have to conclude if he were to grant this mistrial motion. But often defense attorneys will make motions, any attorneys will make motions to simply preserve the issue for appellate review, because if you don't make the motion in the trial court, you have waived your opportunity to raise it in the appellate court. But here's the other thing. Mistrial motions may sound dramatic, but they're actually pretty usual. I had dozens of them lodged in cases I was trying as a prosecutor. I'll give you a very quick example of the run-of-the-mill mistrial motion. If I had a witness on the stand who was testifying and blurted out something in non-responsive fashion that was prejudicial to the defendant and his right to a fair trial, perhaps blurting out something about another crime the defendant allegedly committed that was not charged in the case, you would have the defense attorney properly say, "We object, Your Honor, and we move for a mistrial." Those mistrials are almost always denied, but then they have then preserved their right to raise it on appeal. The other thing is it feels like Donald Trump is perhaps directing his lawyers to be as inflammatory as possible, seeing that this is yet another opportunity to get some disinformation, maybe even propaganda in the public square. And some of these court filings begin to sound like Donald Trump 2 a.m. social media posts.
2 a.m. social media posts. You and I keep coming back to this, Lisa, right? The idea of, is this a legal argument or is this a political argument? I want to hear your take on what Glenn just shared. Is there a basis here for mistrial?
I don't think that there is. And, to Glenn's point, mistrial motions are frequent. They're common. They're very unusually, on the other hand, vehicles for the type of propaganda that he was talking about. And here, the basis for the mistrial motion is this claim of bias that, according to the Trump lawyers, runs rampant through this trial. The only problem with that is just because you're losing on motion after motion or objection after objection doesn't mean the judge is biased. And to the extent that there's some sort of partisan political issue with the judge or his principal law clerk having made campaign contributions, and there are reasons to believe that there might not be, that they fit into exceptions to the ethics rules. My understanding from consulting with legal ethicists is that the solution to that is not a mistrial at all. It's not even to overturn any decision on appeal. It's judicial discipline, and that's it.
To Glenn's point about the way in which this is supposed to sow confusion, doubt, you had a question for Lisa Rubin. If it is on the mind of Rick Stengel, then I'm going to guess it's on the mind of a lot of our viewers.
Well, thank you. I do want to say, though, that what they don't understand is that the judge is biased. He's biased against criminality. He's biased against fraud. He's biased against ridiculous hyperbole in court, and that he expresses that all the time. Trump thinks judge shouldn't be biased against lawlessness, which is what he exemplifies. Here's my question for you, though.
Okay, Rick.
So I was looking at the pictures in the court today, and The principal clerk does sit next to the judge, which I hadn't really ever seen before. Is that common, uncommon?
I've never really seen that before either. On the other hand, their interactions, which I will tell you, I sit at a remove when I'm in that courtroom. The way that this courtroom is structured, the press sits at some distance. There's a bunch of reserved seats for the parties, for friends of the judge, for the Attorney General's office. So we're already at some considerable distance. I don't see the kind of eye-rolling, constant communication and whispering that they talk about in their motions, at least with the frequency with which they say it happens. That having been said, is it unusual for someone to sit as close to a judge as this principal law clerk does? Yes. Does that mean that something is awry or untoward? Not necessarily. And as Judge Engoron has said repeatedly, as the judge, as the elected official here, he is entitled to consult with his staff as he sees fit, so long as they're not other impermissible indicia of bias. And I don't think that Chris Kise and his team have yet shown that.
Glenn, let's talk about that filing. Trump's lawyers write that the judge's clerk is, quote, co-judging, say that, quote, the principal law clerk is given unprecedented and inappropriate latitude. Do you think they're going to be willing to let this go, Glenn?
Oh, no, they're going to probably play this for all it's worth, if only with Donald Trump's base in an attempt to grift yet more money from them. But here's the thing. A judge has wide latitude in conducting the proceedings as he or she see fit. I've seen lots of judges use their law clerks actively during the course of the trial because, let's face it, the law clerks are generally the ones doing the research, handing up topics or even suggested questions to the judge, writing draft opinions. I mean, the law clerks are kind of the behind-the-scenes unsung heroes. And so he may have a somewhat unusual practice of having his law clerk right there available to him to consult in real time. Nothing improper about it. And it doesn't surprise me that Lisa said, you know, based on her observations, it's not quite entirely accurate what they are putting in this mistrial motion regarding what's going on in court.
Lisa, you pointed out on Twitter, where I follow you like a hawk, that Judge Engoron had cautioned Trump's team about this motion. The Trump's lawyer, Haba, had said that they would file this motion in a, quote, delicate manner. I don't know what that means.
Well, I think last week, Alicia, they had a number of conversations with Judge Engoron about some of these issues. Chris Kise first floated the idea that there were some improper campaign contributions on November 3rd. By November 6th, they were seeking guidance from him about filing a mistrial motion and indicating to him that that mistrial motion would have something to do with the law clerk, and they weren't quite sure how to frame it without violating the terms of the gag order. So they were seeking guidance. And at first, he essentially said to them, don't file it. And that quote appears in their motion. But ultimately, what he said to them was, file it, or rather submit it to me through what's called an order to show cause. Typically, an order to show cause is submitted to a judge in their private office called a chambers. The judge gets to review it and then determine what gets filed. That was my expectation of what would happen here, so that you weren't airing in the public domain, as has happened now, all of these allegations with her name, her picture, her campaign contribution history that happened nonetheless. So when Haba said, we will handle it in a delicate manner, that's what I expected would happen. It would be something akin to a sealing or a redaction, so that the most incendiary allegations here would be seen by the judge and the attorney general, but not by the general public, as has now happened.
Well, let's stay on that point, Rick, right? It is not, there's no question why they included her photo, why that felt necessary to a person who has already violated his gag order, whose team has stood behind him as he has done so. You know, there's the legal argument, there's the political argument, and then there's this additional piece that comes from Team Trump, which is an unmitigated effort to intimidate.
And there's the long history of misogyny that Donald Trump and his teams have. I mean, I think he throws that in. He's, you know, the Roy Cohn School of Defense. Try this, try that, do this thing that's unseemly, that thing that's unseemly, do something that you know, look over here, look over there. So it's just part of the tactics that he has always done as a defendant, which he's been a defendant for 35 years.
Right, because the misogyny is happening in the courtroom. Misogyny is also a whistle to his base.
You know, it's interesting, Lucy, because yesterday was like prime toxic masculinity for the Republican Party, at least in terms of Congress. But then there's this toxic masculinity happening in the Trump proceeding, both outside the courtroom and inside the courtroom, too. And I will tell you, just as an observer, the way that they talk about and treat New York Attorney General Tish James, the way they treat a female attorney on her team in the courtroom, and finally, the way that they speak about the judge's principal law clerk, there is more than a whiff of misogyny there. And when brought to Chris Kice's attention, his response was, I'm very happily married and I have a daughter. You and I both know that that's not an adequate defense to charges of misogyny. And the fact that that's the first thing that comes to his mind is an insult to anybody who considers themselves a defender and champion of women in the courtroom or outside of it.
I heard Glenn Kirshner's response to that defense. I did not get to see his face. So, Glenn, I do want to go to you. Judge Engoron is the one who is likely to rule on this motion. Explain to me what happens if Trump's team appeals.
If they appeal, it will come at the end of the trial. And as I say, Alicia, there's not a chance Judge Goron will conclude that he is hopelessly biased and unfairly prejudiced against Donald Trump. So he will certainly reject the motion. And I have to echo Lisa's point when, somebody uses as a defense that they're married and they have daughters and therefore they can't be a misogynist. I would suspect many misogynists are married with daughters, and it's laughable, it's offensive, but it's not surprising.
Glenn.